from one incident.
Yes.
And other than that, there were no other charges that he faced on the predicate charges.
Okay.
Am I correct?
Yeah.
I'm asking this to so that I can find out from you as to what other evidence did you consider, or do you rely on in substantiation of your point that there was at least a pattern of racketeering, demonstrated evidence of racketeering pattern against Major General Boysen?
He was a manager.
Yes, I understand.
No, let me explain to you. He was a manager of this unit since it started, and the commissions of the dates for the commission of the offences 2008 to 2011. He's been all along managing the activities of this enterprise. So it does not mean only because the 5 predicate offences happened on the same day, which was 16 September 2008, it means he's not involved in the others. By association, he gets joined into. That is why also poker legislation allows what we mean joinder under ordinary cases. Where you join people together, you wouldn't ordinarily do that under normal circumstances, but under poker you do that. So he's joined into that pattern of racketeering that happened for all those years. And by association, common purpose is also there. So the predicate offenses, it's only a requirement to charge with racketeering. It doesn't mean that he's not, he was not part of that pattern throughout those years.
Yes. And you're saying that his participation, his being part of those other offenses, is through a common of doctrine purpose, right?
Yes.
But then the question is, why was he not charged with those other ones if he participated through the doctrine of common purpose?
That's how poker works. You get joined in, not necessarily that you physically committed that, but by association, doctrine of common purpose, you are there as well. But it doesn't mean you were there, you committed, you did this. But because you are part of the enterprise, then you are also guilty of those as part of the. That is why you are prosecuted or charged together in the same case.
No, but I'm just asking. Say, look, logically it would follow that you would have to be charged for the predicate charges as well because you participated through the doctrine of common purpose, or even on the predicate charges.
Yes, he was charged with predicate offences. Maybe I'm not getting your question clear. He was charged with predicate offences, which are the prerequisites.
But it was
racketeering.
But it was one incident. The question I have is why not in respect of everyone else, but only in respect of the Makojela case?
Poker doesn't say it must be 400 sins or incidents.
Okay,
as long as the requirement is that it must be 2 or more offences, then they meet the requirements of being predicate offences. And once you have 2 or more predicate offences, then you have met the requirement to charge in terms of section 21E or 21F.
I just wanted to clarify that. Thank you, Madam Chair. Yes. Let me just confirm with my team whether I've got if there's anything I've missed. Madam Nuko, I was just being reminded to just ask you to pertain to page 70 of the DECOC report.
70?
Yes, bottom page 70.
Okay. I see it.
Page 70 or paragraph 70?
Page 70, Madam Chair. Are you there?
Or the pages at the bottom?
Yes. Yesterday, you agreed with Advocate Nkabinde when he criticized through you the Cook panel for not having gone in depth in the analysis of the dockets. Do you recall that?
Yes.
Now, I just want to check whether you still agree with his contention if you start under paragraph D from page 1, from paragraph 191.
Okay.
And where you would see, if you go through it up to page 91, if you go through that, you would realize that the Cook panel, in fact, did analyze the case dockets, and they tell us what they are about. Do you
Which
see that?
paragraph are you referring to?
From 191 to
Page 70? Is it
paragraph 191.
191 up to?
It goes all the way to paragraph 229.7.
I feel it's very superficial and I don't even believe it.
No, but
Because
the
they
point.
should be saying exactly
Please
what
allow
each
the
docket-
witness to answer
Okay,
you.
thank you. I'm
You don't have to interrupt
okay.
anybody.
Okay. I'm just saying that, in fact, the statement put to you by Advocate Nkabinde, which you agreed with, was that, in fact, they had failed to analyze each docket like you did. All they did was just to do to provide a laundry list.
No. The issue was that there are some dockets that are missing where there are no explanations or analysis on. And if you are referring me to paragraph D up to 191 up until where you're referring to, I will still say it's very superficial. You cannot be relying on this to make a decision. For you to make a decision, you must go thoroughly into each and every case, analyze it. Then you will be able to know, with a fine-tooth comb. Fine what? Fine-tooth comb, yes. You must go through that and be sure that you... So this is a very superficial analysis that one cannot rely on to make a decision. More information was needed to know about these cases, to make a decision to withdraw the racketeering charges and all other charges predicating the rest.
Okay, I've got no further
So it
questions.
was on that basis that we're saying they did not read the dockets.
Okay, thanks for the clarification, Madam Nuko. Thank you.
Thank
I've
you.
got no further questions, Madam Chair.
You also look at paragraph 191, the one that you've just referred us to. Just that paragraph. Look at the words in emphasis. Those underlined words emphasizing that there was no shred of evidence linking them to any offense. In the next line, it says they also allege that the accused also killed civilians and
one looks at it, there appears to have been some analysis of the dockets.
Yes.
I'm not saying that the conclusions drawn are correct or not. And insofar as the question of whether there was tangible evidence or not, ultimately that is the question for the panel to answer, because that is what Advocate Chauke is accused of doing, that he made some of these decisions where there was no evidence. And I think at this stage, Madam Chair, I wouldn't want to be seen to be.
Yes, but you are an evidence leader. You know these records better than us, as you presented the evidence in chief. Now, I'm asking you that now that these reports are not even giving us the summaries of the dockets, you remember Advocate Baltoi said she didn't read the dockets at all. She relied on these reports. Do you remember?
I recall that, Madam Chair.
Now, this very report upon which he relied do not even give us a summary or summaries of any of those dockets, so that we can have a sense of whether the contents of the dockets were considered to make a determination whether there was a case, prima facie case or not. So without that, and somebody comes and say, from the look of this report, which does not even summarize, not even in one line, just simply giving us a broader picture without summaries of those dockets, upon which Advocate Batoi herself said, I didn't read the dockets. I relied on the DeCock report. But the report does not give anything insofar as each one of those cases, the 23 dockets, are concerned. And I'm asking you, as you lead, and that will help us, because the terms of reference suggest that there was no evidence.
Madam Chair, can
Now,
I get? Sorry. Okay.
No, wait a minute. This very question comes from the very paragraph you drew our attention to. And I'm saying to you, as we ultimately have to decide that point, and of course you will argue it, but now that you raised it, I'm asking you, could it ever be correct, now having even looked at the summaries, that you don't take issues with? And we know that the report that was relied upon does not even give summaries. They emphasized words without shreds of evidence linking them to any offense. What do you make of that?
Madam Chair, can I confer with my leader before I make that concession?
Yes, if you can't assist me, it's fine. I understand.
I do not want to be seen to be not willing to make a concession when I have to, but given the fact that there are still going to be witnesses that will still come to and talk to the report.
You may confer with your colleagues.
Yes.
I thought that if you will be able to help us because you raised the point.